Good afternoon, everyone. Good afternoon, Gurunath sir.
Hi, good afternoon, Tanay.
How are you, sir?
Yeah, all good, all good.
I'm good. All set for the training, sir.
Yeah, sure.
I would request every one of you to please be on mute during the whole session. Sir will address every questions after the session. So if you have any doubts in middle, you can leave your doubts in the chat box. Sir will address them later on. Sir will give the presentation on bid process, claim, contracts, and risk management. So over to you, sir.
Thank
All the
you.
best. And
Yeah.
everyone, please attend. Thank you all.
Hi, everyone. Good afternoon. Welcome to all. So today it is
Good afternoon, sir.
I have taken a drop from the ocean. What I am going to give you is just a bid process because directly going to the contracts management is like a middle of the project. So I've taken from the initiation of the project, like bid process, how it happens. Then we comes to the claims. How the contractor start claims and contract risks. Contract risks are those where we have contract agreement between two parties, and in those contracts agreement, how best we know the contractual, provisions and risk management. So these are the things which is like comprehensive has taken, and it is very good for the aspirants who are going to proceed their career in the contracts management. It will be more helpful for them, and let's see how it goes. Okay, now we'll start this one. So this is just a illustration picture which I have taken from our C6 package. The left side is the FSLG launching is going on, and the right side is SBS launching is under progress. So myself, Gurunath Sawle, I've been there in Gulf almost 20 years, and here in India now. So whatever it's like knowledge sharing, just whatever I have learned. So I'm just keeping it in an open book so that it will be helpful to each and every one of our colleagues. It's like a bid process, claims, and contracts risk management in construction projects, especially. Then we'll start with bid process. Bid process, how it starts, like bid invitation. First, the client will forward the invitation. Then there will be instructions will be there in the invitation where the bidders will get the instructions how to bid and what all the components to be considered, and all those details will be given to the bidders. Then there will be a pre-bid queries. When you are bidding the project, then definitely there will be some queries will be there, some doubts will be there. So those can be, communicated with the client so that it will be, justified and it will be clarified so that it will also become a part of the contract. Pre-bid queries. Then we go for a pre-bid meetings. Before bidding a meeting, before bidding a project, quoting a project, there will be a pre-bid meetings will be there, with each of the bidder, or it will be together they can call. So I can share you my experience, like Qatar metro project, where they called all the bidders at one point and they said whatever contract is mentioned is fully binded. There is no revisions in that. If you agree, then quote. Otherwise, don't quote. So this is simple, 2 words. So that's how they can communicate so that that will be become the part of the contract, and everybody will have an equal number of deliverables and in a same process. How if everybody codes in a proper way, then only it will be segregated and comparative statement can be made and they can take the decision on that. Okay, we come to pre-bid meetings. Then once bidding happens, then post-bid meetings. In post-bid meetings, those will be like selected bidders will be there. If we call it 5 bidders are there out of 5, there are 3 bidders are okay. They are well qualified and in the sense they complied very well and the scope has been considered fully, so that the client can call those 3 bidders and start negotiations. Then submission of bid quotation in sealed envelopes. what happens is it should be like bidding should be in sealed envelope. So it should not be seen by anybody, like commercial bidding, then technical bidding, and any additional annexures that can be added into that. It is mentioned in the instruction to the bidders. Those things they have to keep in mind and follow 100%. If at all, if they miss any of the points as per the instruction bidders, then it will be disqualified. Then bidding process, bid invitations, like tender invitations shall be forwarded to minimum 5 prominent contractors in the country. If 5, it can be 7, minimum 5, it can go to 10 up to no issue. Then if required, may invite foreign specialized bidders too. If it is, it's like some very specialized project where you require some specialized, but nowadays in India, everything is available. No need to go for a foreign country. Then instructions to bidders. Though, as I mentioned, the instruction to bidders, the technical, commercial, and contractual instructions are issued to all bidders with special instructions as applicable. So those instructions are very, very important for the bidders' point of view, so that they should comply each and every, instruction and bid accordingly. Pre-bid queries, as I mentioned, pre-bid, prior to the quotation submission, contractors may ask queries related to the bid. Then pre-bid meetings, so that can be held prior to the meeting, prior to the bidding. In that pre-bid meeting, client may add addendums, inclusions, or those also becomes a part of the contract. That we need to understand only what agreement we have. Addendums are also a part of the contract. Then post-bid meetings, if required, post-bid meeting shall be held by the client individually. So that, at that point of time, you have to call individually so that, we will come to know what exactly they have included, what they are not included, and technical compliances, qualifications, those things will be, again, it will be scrutinized and comparative statements will be made accordingly. It will be taken to the higher management of the client to check and finalize. Then bid quotation, as we mentioned, consists of commercial bid and technical bid and special qualifications such as items supplied by the client. Some items are supplied by the client or by others. For example, the things like in our project, if we put a condition to the contractor that the entire steel requirement for the project reinforcement will be supplied by the client, then it will go to that cost will be separated, or it will not be quoted in the contract, so that every contractor will follow that same rule and it will be come to the conclusion. Now, selection of bid. Okay, now we come to the bidding process completed. Then, based on compliance of technical scope and comparison among bidders' obligations, those things are vital things where we need to check compliance of all technical aspects and scope of the work, and even small things like finishings and all those things need to be checked thoroughly. Then only it will be fully complied. Then commercial compliance is kind of comparison and meeting the budget cost. The client has some budget in the mind. So this is my project cost. So within that, if anybody quotes, then definitely they have a tentative cost in their mind. And if they match with that, then it will come to the budget of the cost. Bid quotation consists of commercial bid and technical bid in sealed envelopes. As I mentioned, it should be in sealed envelopes. Whatever you are giving, it should not have any name of the bidder name. Bidder name will be inside. Outside, it should be sealed one. And you have to mention commercial and technical as well as additional annexures, whatever is according to the bidder instructions. The final is the L1, the lowest one with comprehensive compliance contractor shall be selected. That has a huge comparison meetings and all those things. Based on that and previous record of the contractor, that's also matters. How many projects he has completed. Is there any issues in the payments or any other bankruptcy or something like that. The records will be checked thoroughly, and then only the project will be, letter of intent will be issued to the contractor. Once it is done already, then we'll come to the contract correspondences. Now contractor is on board, kickoff meeting happened, and now contractor will start contractors correspondences like RFIs, relative approvals. These all, like, first of all, they have to exchange the formats of all those things, and then they'll come to, and all these RFIs correspondences should be reverted within 21 days. There should not be more than, if delays, then it will attract claim. So that is the main issue. So that has to be followed strictly. If not responded within 21 days, claim doorways open for the contractor. So that's what, it is 21 days, or it is maybe different to the different contracted way. Delay notices are very vital notifications, need to be addressed comprehensively within stipulated period or as agreed. Normal correspondences and delay notices. Delay notices contains a lot of hidden things in that, like additional cost, additional time. So those things we need to justify, and immediately, I mean, within 21 days, we have to justify and revert back to the contractor. That practice is the best practice of the contracts management. Then in our project, we have uncharted utilities and charted utilities. The uncharted utilities risks. No, there are many risks in the uncharted utilities. Along our ROW, there are many services which are crossing every location at the exactly under the pier. So we have to divert all those services. Uncharted utilities are services of water line, electrical cables, drainage system passing through ROW need to be diverted as required. So this already, it has been happening, it is going on. And uncharted utilities diversions estimates are based on quantity and rates. This is not a lump sum contract. Our contract is a design lump sum contracts, yellow feeding book. Okay, in that it's a lump sum contract, has a different payment procedure, and the quantity and rate based that payment system payment procedure is different. That's based on quantity, and this is based on percentage of work done. Then a dedicated provisional sum is allotted for the uncharted utilities in the contract. So there will be a huge risk also is a part of the uncharted utilities. If you break any main water line to the city, then there will be a huge risk. So that needs to be checked thoroughly before excavate anywhere uncharted utilities are passing through. And all those things contractor has to take care of, and that is the risk which they have to consider at the time of bidding. Contractors' obligations. Time is the essence of contract. Time is very precious in the contract, where and what has to be completed, milestones to be completed accordingly, so that time is the essence of any contract. So the engineer or employer must highlight contractor's obligations in each correspondences with specific notice. This is the one which we are practicing here in our project. We need to highlight their obligations. Sometimes contractor goes beyond, they take their own way, and they say that it's not part of the contract. That we need to re-establish and highlight those clauses, and send back to the contractors. Look, this is your obligation, and you have to fulfill this one without any additional cost and time. Third point is the engineer execution team must be aware of these provisions which the contractor need to complete. Our execution team should be well versed with the contracts, obligations, technical specifications is very, very essential. Before we start, we should read the entire contract. then we come to know what exactly we are doing at site. Doing execution is different, and reading and understanding the contract is different. First, we have to read the contract, then, or along with the installation, we should read at least all clauses which are mentioned over there. Then we will understand what exactly we are doing in our site. RFI approvals. Yes, RFI approval is one of the issue what we have in our project. So RFIs shall be approved as per the technical specifications, and the RFI should have comments exactly what we have observed at the site. That is very important. That should not be like a monologuous comment, like same comment in all RFIs. No, when you go to the site, then definitely there will be different aspects will be there. When we go to the site, then we see something different. Those all things should come on the RFI, comment box. So that is the part of the, very important part of our inspection. Then partial approval RFIs shall be proportionately bifurcated for the IPC payments with clients' approvals. Sometimes what happens, for example, post tension is done, but graph is not there. So that RFI should not be stopped. So you can mention over there 90% of the work is finished and 10% can be released after submission of the graph or relevant documents or as-built documents. Those things can be mentioned clearly in the RFI. Then it will be easier, for anybody to. The contractor will not have any, like additional cost or something. He will not come back. Oh yeah, there is a valid reason is there. Of course, 10% can be held up. We cannot hold 100%. That we need to make it sure. If withheld amount mounts accumulates unproportionately without valid reason, the contractor shall claim finance charges. So this is very important. Any amount which we are holding, there should be a valid reason. And if it accumulates in a huge amount, then on that huge amount, the finance charges that as per the bank interest and compounding interest is put, and all profit and everything, put and then charge for claim. And that will be the very high amount, which very, very difficult to justify that one. That's why we should not allow that situation should come to us. We should mitigate that. RFI is the main thing. And if work is not done properly, you can have NCR. NCR is your tool where you can, apply as per the contract. Then risk of claim management. Are the contractors entitled to additional time and cost on project commencement? Just I'm asking question. So are they really entitled? That we'll check. The next. What are claims? Okay. Now claims are not disagreements. So this is a disagreement between two parties. Then there is a problems. Then or disputes. Yes, disputes. When it is disagreement between two parties, then it will go to the dispute. A claim is an unresolved disagreement where the parties take a formalized stance over money. So it comes to the money, where there is a disagreement and contractor takes his own stance, and then it comes to the conflict or dispute. Then claim arises due to fault of parties, not one party. There will be two parties or many other parties. So fault will, that claim will arise due to the faults. Then what are they for? What those claims for? Requests for additional time because of unforeseen events and some known events. Unforeseen events are like, our contract has all, things which were very clearly mentioned, and it is very precisely taken care of all unforeseen events, and any events which they are known, then that can be avoidable. If contractor is not avoiding that, then it will not be, claim will not be considered as a legitimate claim. Reimbursement for loss and expense not foreseen in the tender rates. If contractor has not seen, reimbursement of loss or expenses, has not considered due to unforeseen conditions or some those things, because tendering is a very vital part. It's a huge, people think, let me tell you, because I have spent a lot of time in the tendering part. So tendering is need to see the duration of the project and beyond the project, even around the project, what all the things are there. Those things also need to be considered in the price, what they are quoting. When they come to the cost because of something that should not have happened, then in bidding time itself, they have to anticipate something, so that for that they have to give some corpus for that, so that, if anything goes wrong. And at the same time, you have to take care of, it should not go beyond. If you put all those things, then you will become the higher bidder and you will not get the project. So those things are very, precise and important part, and that comes by your experience and, previous project deals and all those things. Then contractual claims. Contractual claims must be based on specific provisions of the contract. Whatever contract is mentioned over, specific provision should be there. Then only contractor claim will be entitled. The contractor is not entitled to extra just because of unexpected difficulties or unforeseen expense. So contractor will not be entitled for those things. Those contractor need to put in his price and, or, fulfill the requirements. Considerable variation among contracts forms as to the ground for claims. Any claim, it should have a proper ground. It is not like something which is coming without any base. There should be a proper base and there should be a proper justification. Then only claim will be considered and it will be processed. Distinctions. There will be, many distinctions will be there. The contractor is entitled to additional time or payment when particular event occurred in strict compliance with the contract procedures, notices, informations, etc. So contractor need to give the notice for that particular event which is happening, which is out of the scope. And there should be a proper information and there should be a budgetary cost. This much of cost is going to be incurred for this additional cost, so that we can, as engineer, we can convey to the client and get the approval for the further process course of action. Otherwise, contractor may sue at local law. If we don't consider his variations under the conditions with proper notices and informations, he can sue at the common law. Common law damages agreed between the parties. When we go to the common law, then definitely the contractor will not get the next project from that client. So that's also matters. So that is not the way to conclude the variations or claims. Otherwise, matter referred to arbitration or litigation. So that is another part of the contract. Then FIDIC principal claims headings. There are specific clauses in the FIDIC contracts that is clearly, comprehensively, they have taken all aspects of the project, non-prejudice to any party, or maybe a contractor, maybe a client, so that it will be equally distributed the risk and managed very well. So in our project, we are using Yellow Book FIDIC, so that it will properly balanced. Specific clause sets up disruption claims and delay claims. Some clauses are mentioned very clearly. If disruption happens, due to some, excess to the contractor or delay in drawings or delay in approvals, and those things will accumulate for the delay claims. Those are mentioned very clearly in the FIDIC. I've taken just one, example from the FIDIC clause 2.1. If the contractor suffers delay, incurs cost as a result of failure by the employer to give any such right of possession within such time, the contractor shall be entitled to subject to clause 20.2 claim for payment EOT. So these, payment of such cost plus profit also we have to give. So that's why any project we start, so that access should be given with all drawings availability, all material, list availability, so that there should not be delay. We should not make any delay to the contractor. So where we can save employers money. Then one more clause is 8.5. It says if authorities delay, disruption was unforeseeable, then its delay disruption will be considered as extension of time, and the employer shall pay below such damages as the contractor shall have incurred by the delay. So even authorities delays, those also considered, because those are not in control of employer or the contractor. If contractor follows procedure as per the authorities requirement, even then after that he got delays, then he is entitled for the additional cost in time. This is just an example. Now claims guidelines. So how the claims, because these as an engineer we need to check these. When the contractor's claim comes, we need to check all these points. Must be made promptly, honestly, not at final account. It is very, very important, because when the claim occurs at site, immediately has to give the notice and give the approximate price or approximate cost, then submit the exact amount as per the with proper justification. Specific and not an exorbitant claim. Sometimes contractor exorbitate the cost. He takes a higher cost. And at that point of time also, we need to check whether these are genuine rates, from where it is arrived, and how these rates have been arrived. Those all need to be checked thoroughly, and must relate to cause and cause to effect. So there should be a cause, and there should be a reason for any delay. So that we need to check. Relate to project loss that could not be claimed as a variation. Project loss is if sometimes contractor incurs loss, so that cannot be claimed as a variation. So that is their internal issues due to some delay in procurement, delay in some other aspects. Those cannot be considered as a variation. Causes of claims. So why claims come into picture? Because our project is already done, everything all is been given, but still claims comes. Nature of construction. The construction of the nature of the construction is something which is different than the normal. Then definitely there will be new things. For example, we take something new comes, so claims may occur, but there also we need to have proper justification. Division of responsibilities. There are many contractors in one project. Definitely there will be responsibilities are divided. Again, there will be a integration. For the integration purpose, again you will get claims from other parties. And poor pre-contract planning. Pre-contract planning is bidding process. Or after bidding, you can say the planning, what we do, which activity takes how much time and all those things. If there is not proper planning, then also claim may rise. Inadequate tender information. In tender also, what I mentioned, the instruction what we have given and what drawings specification, technical specifications, BOQ, what all we have given is comprehensive, and it is in full scope of the project. Then if it is something less in that, definitely there also claim may come into the picture. Wrong tendering procedure. Bid process, what we discussed, if bid process is not done, what we have mentioned on those steps, then also claim will take precedence. Extensive variations. Sometimes extensive variations are putting, then also that will also become something additional to the project. So that we need to, as an engineer, we need to check that thoroughly and make it sure and justify, and immediately we have to give it back. So this is the main no, any variation comes immediately, we have to revert back to the contractor within 21 days. That is the whole mantra you can carry with you. I would, because that's what we followed in our package, and it is very successfully completed. So it may help others. So that's why I'm just putting this across the you know video. So design team delays. Sometimes there will be a design delay also. If there is something design delay, definitely that also calls for a claim. Delay in approval procedures, as I mentioned earlier, drawing approval, material approval, method statement approval. So these things, again, that will also have some impact on the claims. Unforeseen events, any unforeseen events which is not there not covered in our, just proper specifications and contracts obligations, then again, it will, come as a claim. Loss or expenses. Just will elaborate in this little. Contractor must prove his loss or expense. He has to prove that if he is really loss happened due to some reason, if he has to prove with proper, cause effect justifications, so that it will be considered. Demonstrate this loss is within the contract's term. That's also important. The loss is happened within the contract's terms. If it is something happened outside, so that will not be considered. Such loss and expenses has been caused by the employer. If employer caused such losses, that also, becomes under claim. That is, the contractor must prove causal link. As we mentioned earlier, the causal link has to be there. Anything, any claim you are doing, then you have to mention all the causal link. The engineer must ascertain the loss and expense or damage. The engineer has to see whether really happened at site, or we have to ascertain all those in detail with evidences and backups. If not there, then we can ask the contractor to submit all of that. Loss of money contractors should have, but did not receive because of events. The loss, when it happens, the money contractor should have, but it not, yes, did not, because he didn't receive some payment from the client or something, so he delayed. So then their loss happens. Expense, greater cost because of these events. So when he's spending more and additional items are coming, and then expenses will be higher. Loss expense claims are based on delay in completion and also because of the regular progress of the work have been disrupted. Mainly when the contractor which is all machineries, material and labor at site, and suddenly there is an obstruction at site due to some reason, due to, you can say, some villagers problem or some issues over there, then suddenly the contractor will be, at standstill, and his machinery will not work, labor will not work, and then the idle charges will come into picture. Valuing loss and expense, that we this loss and expense we need to check very thoroughly, and it requires sound knowledge and competence in the construction procedure. The construction procedure need to be understood fully. Careful study of contract conditions. As I mentioned earlier, you need to read the contract conditions and understanding of their application, which is the vital part of the construction management. Because we focus on the construction management, we left behind the contracts conditions. Those are very, important. So that awareness has to be raised, so that, we can avoid many risks and many problems can be avoided and claims can be minimized. Understanding of the relevant case law. So whatever, cases are there, those we need to understand. Loss expense clause protocol. So there are some protocols how to, we have to see loss and expense claims. If contractor claims, the contractor must notify the engineer in writing within 5 working days of the default. If any default happened, he has to write back to the engineer within 5 working days, and we have to justify and we have to check it and revert back to the contractor, say that is it genuine or not. The engineer must establish the time lost and the additional expense incurred by the contractor. So that's why we need to note down whenever the contractor's work held up at site, we need to note down the time and the date, so that due to unforeseen events or due to their own, if it is their own problem or breakdown, that's there, but that also need to be noted down, so that due to the less non-management, the breakdown happened, or non-maintenance or preventive maintenance, those things happened, so that can be considered, that cannot be considered as a additional cost. Then where the delay prolongs the works, the delay is added an extension of time to the contract period. If delay prolongs the works, then definitely there will be extension. The additional expense caused by the delay is added to the contract sum. In our project, like how the variations has added to the project value will increase substantially according to the variation value. So those will add to the contract sum, the final contract sum. Investigating claims. As an engineer, we need to be, vigilant enough to investigate the claims. Once the claim comes, then we need to investigate. Suddenly, we should not go to the, submit to the client or start calculating the cost or something. No, first investigate whether, consider these things. Where the party's intention is, the party's intention is what exactly, why they are putting these, to claims, why they're putting, and what is the intention behind that we need to read out and check. What time during the contract does the claim refer to? The claim which is claiming, what time it has occurred and when he is putting that claim, that also need to be noted. Does the claim alter the nature of the contract? If the claim is altering the nature of the contract, then also we can reject that claim. Delays are rarely one party's fault. Delays, definitely there will be two parties' fault. You cannot blame to one party. If something delay happened, there will be two parties will be involved in that. Frequent inaction by the employer, agents, and mess up by the subcontractors. So then there is also, if frequent inaction by the engineer or by the employer, mess up by the subcontractors, then also claim will arise. Evaluating claims. Loss should include the original profit expectation. The original profit expectation. Then loss of profit from contractor's mismanagement is not recoverable. If contractor is mismanaged, his material, machineries, labor, that is not recoverable at all. It is go to their risk. Evaluation is considered under prolongation and disruption. If project prolonged continues and there will be a lot of disruptions, then also claim may be considered. How the work was affected. Loss of output. Output is not coming as per the machineries, labors are there at site. Labor and plant standing idle time, as I mentioned earlier. So if there is due to some reason, if plant is standing, idle time, that also affect. Part-time labor and plant utilization. If part-time labor are there and they'll not be proper, continuous present, then also that will affect the progress. Out of sequence of operations. Sequence of operations as planned. If they go haywire, definitely it will decelerate their work. Additional labor cost, night work, weekend working, etc. So those things also, we need to check for the claim verification. Additional cost resulting from plant and operatives being brought back to site after having already left. This is happening in our already LG is going up to the, and there is an obstruction, it is going back. Again, he has to come back to complete those, area, those. So that's also attracts the additional cost. Acceleration measures resulting in uneconomic use, labor and plant. This if you are using your labor and plant uneconomically, then also those, we have to check whether really if they're showing their number of labors, but progress is not there. So those things we need to see. Proportionately, there should be a progress. Or is there any, deferred effort by the contractor to slow down the project? That we need to, this is really very interesting part, where we need to note down all these parameters at the site. And, I would suggest like our execution team should keep all, happening every day. Diary is very, very, essential. Keep all records. Those things come, it will help us to evaluate additional claims or UOTs or many things. This is just a illustration purpose. I put Anand Via station progress. So this is, which is in progress, and progress is going very well. Then establishing a claim. We need to have full square details, all sites details should be there. Even one detail is not there, then we will not be able to, establish the claim is genuine or legitimate. And proper records, all records should be there. Adequate notices, as I mentioned, though the event occurred within a week's time, they have to give the notice and give the followed by additional approximate cost and time completion. Must link, cause to effect. Those also need to put it. Contractors entitlement, reasonably incurred cost, additional on-site preliminaries. Like these are like construction, but site preliminaries is another cost, which is part of, they put it in the variation. Additional cost, additional plant and tool hire, disruption, head office overheads. If project is happening at site, but from the head office, there are two people working for this project. Their man hours also be included in this. That for the understanding purpose, I'm telling you, loss of profit. If any loss in the profit, that also they'll put into that. Finance charges, as I explained, finance charges are, very hidden part where we should not delay any payment or any to the contractor, so that, it will open a gateway to the contractor for the claim for a finance charges. Additional preliminaries, paid for additional requirements for the period of delay or caused by the disruption. These remunerations of site staff and travel, plant and scaffolding retained, temporary power, distribution, light, temporary offices, storage, telephone, Wi-Fi, internet. These are, when they claim these preliminaries also, they will add into this. Additional preliminaries, insurance, additional effects of, inclement weather. Then attendance of subcontractors, increased acceleration cost. I have just considered some few. There are many things are there, which it is a endless list actually. If you go in that, and maintaining temporary facilities at sites such as water, sewage, safety and power distribution, time related temporary works.
Sir,
Okay. Yeah.
Sir, we have lost your presentation.
lost the presentation?
Yes, so we cannot see your presentation. Yeah. We
Okay,
thought you're done with the presentation.
Okay, I'll reshare again. Reshare. Okay.
Yes, sir. The sharing has been stopped.
Yeah. 1 second. Is it visible now?
Yes, sir.
Yeah.
Yes.
No, sir, still it's not. Now it is visible. Yes.
Yeah, thank you.
Yes.
So we were at, what was the
33 or 34? 33, I guess.
33? Okay. Oh, it is going back. No standard for acha. Ascertaining the cost, finance charges, head office, remunerating disruptions. Okay, additional preliminaries. Yeah. Then remunerating disruptions, additional hours of labor, hourly rate, additional plant requirements, materials ordered under manufacturing and in transit, total cost of the disruption. Then head office direct expense, which I just noted, can recover head office cost incurred directly by a delaying disrupting event. Head office staff spent additional time dealing with the situation. Includes time gathering information to ascertain the loss or expense. Finance charges and in interest. Interest on outstanding sum is allowed when employer delays statements, settlement. When that's what I mentioned, or payments, what we are doing to the contractor, we should not delay. As per the contract, we should give them. That's why RFI also, we cannot hold the whole RFI. We can hold 10%, 10, 5, or 1 to 10%. Between that range only we can hold proportionately. It is part of the contractor's loss. Financing charges. Contractor is entitled to loss expense for the cost of financing. So they can recover in that. That loss also they can recover. So that's why this is very vital part. That's why we should not hold contractors' money without valid reason. If there is a valid reason, yes. If there is a NCR, issue NCR and put appropriate or proportional amount can be held up. Ascertaining the cost of finance. Same rate of interest. I'm just elaborating here finance charges, how it works. Once if they charge, what all they put into that. Same rate of interest as the contractor paid, to the bank. Rate at which in general borrow money if contractor pays well above or below market rates. Whatever banks give the interest rate, that same interest will put. Calculate the cost of finance on the same basis as contractor bank charges. Use the same rates and compound the interest. See, this is the repercussions are very high. That's why we should avoid this. Any finance charges, we should immediately reject if it is valid. It's not valid. Then we come to preparation of claims. Principle, there should be how claim should be prepared, because we are not putting any claims, but we are checking the claims. So that's why this slide is for no standard format. There is no standard format that for any claim. So it should have some protocols. Make the claim easy to follow. If contractor is making submitting very complicated claim, then you should write back to him saying that it should be easy to follow and properly elaborated. Set out calculations clearly. Any calculation, rate analysis, and how indice is considered. All those things they have to make it very clearly and make it understandable. Ensure the facts are accurate. Facts are whatever facts they are putting in that should be accurate. And in claim management, the ethics and the honesty of the contractor is always considered. If once contractor loses that confidence, then engineer or employer will not believe the contractor. That's why they should be, accurate and reasonable. Attach copies of all documents and correspondences referred to in the claim. So whatever the claim they're putting in, so all documents, evidential copies should be attached with the claim. Include all relevant informations. Whatever information are available with the contractor, those all should be included. State clearly all submissions of law. Law or any clause which are there, that should be mentioned clearly. Well, it should be well presented. That's also very important. Claim presentations. Claim presentation is always he who asserts must prove. The person who prepared the claim, he should prove it. So that is the requirement. Claim must be documented. Site records must be kept for the time the relevant work was executed. That's what I mentioned, site records. Every day when we at site, definitely we should put the date and time for first half, second half, what all happened, whatever is happening, that we should pen down. So it's always, it's helpful for you to go back and read that and, put contractors, for correspondence writing back to the contractor. It is really a great practice. I would suggest each and everyone must keep that one. Records. That's what we are talking about. Master program with update, progress photos or videos, site diaries, which I mentioned 2-3 times, weekly returns, drawing register, correspondence, minutes, notices, recorded measurements, daily labor. If it is, ours is like any critical measurements which are done at site, so that also we can keep. Daily labor, plant and staffing records. Contractor submits that, but it is to be rechecked whether it's really correct or corrected one we can note down. This is again an illustrated picture which I have put here. 432 onward sky view of C6 package. Then claims contents. What should have? And the claim should have contractual basis, narratives, technical justification, rate analysis with backups, evaluation of claims. Then conclusion of claims, then appendices. Though this is a proper systematic way, they should not send one letter, this is my claim, then it should not consider that one. It should have a proper backup and justification. Claim management, basic rules. Anticipate possible claims and plan accordingly. Don't wait until they happen. If any claim is about to happen, we should anticipate it and work on that. Prepare, whatever the submissions to be made to the client to get the approval. Those things has to be done prior to it happens. Keep a good factual site diary and accurate records from the start of the contract. Why it is repeating again and again? Because the keeping factual site diary is very, crucial part, because as we keep all those records, that's again helpful to write back efficiently to the contractor, and we can reject or we can deny the claims which contractor is putting back to us with those valid reasons. Then only your rejection or denial will become more effective. Record the requirements for giving notice and ensure staff are aware of these. So these things, our staff should know all of these things. Review all correspondence with the employer and minutes of meeting which could have an impact on claims. So we should review with the employer all correspondences, then it will have a good impact on the claims. Escalation cost. Escalation claims cost increases as the project duration prolongs indiscriminately after the contract duration. See, escalation, what in India we have in our contract, what we have is like steel on material escalation on based on indices. What indices? That escalation is the another part. This varies from project to project. This escalation is escalation claim cost increases when the prolongation happens in the project due to various reasons. The escalation cost also comes into picture. Must have storage, strong evidential document from the beginning of the project. So to avoid all this, we should have a evidential documents from the beginning of the project. If disruption prolongs, escalation of cost may arise. So we should avoid by putting all, contractual obligation of contractors, all claims at the right time. If it delays, definitely it will compound the claim. Contract and law are closely associated. So let me make it, any engineer can become a lawyer, but lawyer cannot become an engineer. You should know that. It's very interesting. So any engineer can become a lawyer by knowing the contractual obligations, but lawyer cannot become an engineer. If project gets into dispute, agreed contract clauses gets activated. Project gets into dispute, then contractual clauses definitely whatever obligations, those all you have to put in SOD, SOC, those goes on. A proper evidence, SOC becomes a base for the claims in the court of law or in the dispute board or DAB, dispute education board. So, so those things we have to put in order, statement of claim, statement of defense, all those things. Well-crafted contract held accountable for both the parties. The crafting contract is itself is, it's an art. When we craft a contract, definitely it should consider all aspects of the project, in and out. There should be any unforeseen events or any additional cost, which for that all we should put clauses so that we can minimize the additional cost. A well-crafted contract can be in those conditions, we can minimize the additional cost. Force majeure clause is inevitable. Depend how best you submit and prove the case. But again, force majeure, FIDIC has mentioned very clearly, in those circumstances only the force majeure will be applicable. I've just taken one small, example how the claim, FSLM girder reinforcement. Just an live example has been taken as the tender drawing, girder reinforcement is increased significantly a new set of drawing has been issued to the contractor. At that point of time, the contractor is eligible for the claim. The same is, depicted in variation order summary with illustrate the detail of the changes, quantity and cost as per the instructions issued by the engineer and employer. So this is like a determination of the variation. Then conclusion of the variation. How will conclude? Claim conclusion. It determines that the above event occurred due to the changes initiated by the engineer or employer. The contractor have procured additional machineries, reinforcement, maneuvers, and accessories. The amount requested in the above is the firm cost of incurred at site as per the prevailing conditions, and the same has been accomplished at site. And on top of that, the contractor will put that, in the process of completion, as per the schedule, the contractor has taken the numerous risks. He will tell that, okay, for this, we have taken a lot of risk to complete this one because we have to additional cost, then additional reinforcement, additional procurement, to accomplish all those things. Then risk and contracts management. So in this case, let's implement with resilience and alertness every day till the completion of the project. This is a small quote what we are trying to address to each and every one of our colleagues. let's whatever we have learned in this, so let's implement so that we can minimize the cost of the project. So thank you for your time, and if you have any questions, you can ask.
Sir, there are few questions in the chat box. You can address them first, and then we can, keep the forum open.
Okay. Chat box, or they can ask directly. Prolongation cost is applicable for internal milestones. The